Hello, good afternoon. This is Mike Haber and Ed Martinez, and welcome to At Your Service with Haber and Martinez, episode number 23, which I have entitled Crim Pro 101 for Reals. And basically, I think Ed and I have, in discussing types of things that we want to talk about so that we can assist y'all in understanding how the system works and give you pro tips on how to deal with the system should you or anyone you know ever get caught up in it. One of the things that we observe regularly in our practice is just how little people actually know about the reality of the system, yet how much they think they know about the reality of the system, and then the convergence of what they think they know and what they don't know, how it affects them negatively. So with that in mind, we're hoping to be able to take you through a little bit of a discussion with some practical tips and information. Welcome back, Ed. I hope you had a good Thanksgiving and a happy Hanukkah.
I did. It was an uneventful Thanksgiving.
Did you spin the dreidel?
No, not yet. But we're doing it tonight.
All right.
I'm an honorary Jew, so
We're all honorary Jews, Ed. Everybody's an honorary Jew.
I will spin the dreidel. We did light the candle for the first night of Chanukah, as Adam Sandler calls it, and
8 crazy nights, Ed. 8 crazy nights.
So yeah, and now I've got like 3 or 4 what do you call it? Menorahs. Jeez,
Good for you.
We've got about 4 menorahs all over the house. I didn't understand that is like a Jewish tradition. You get like a collection of menorahs and you put them all over the house. Is that what we do? We just put
Hey, why settle for one? It's like firearms, or dogs, or cats.
Or dogs or cats. Good point.
So anybody who saw the promos that I put up for this episode probably saw the flow chart that I located used called "What is the sequence of events in the criminal justice system?" And Ed and I were just talking a moment ago before the show started about how complex that flow chart is.
Dude, I had no idea that what I do is that complicated.
It's amazing.
Actually.
It's actually a little intimidating when you look at this thing, with the colors and the lines and the ups and the downs. I mean,
but it's true. It's absolutely true. I just didn't realize how. We don't realize, Michael, since we do it all the time and we just grew up doing it, is how fast our brain works. And this is exactly what goes through our head. And sometimes, correct me if I'm wrong, we are 20 steps ahead of this flow chart and we're still all the way back at the back. But we're anticipating all these different moves in our heads instantaneously.
Well, that's really the main reason to hire a lawyer, because we understand these things. I guess you could say the same thing about anybody who's an expert in their field, right? I mean, a surgeon, they're going in to do X procedure, but if you've got a surgeon who's done enough procedures, they're thinking about 500 different possibilities that might occur, predictable, reasonably foreseeable, and even unanticipated. They've got people on standby, they've got equipment ready to go, they've got different coagulants or drugs or, whatever they may need. Well, that's kind of like what we do, but that doesn't help, John or Jane Q citizen in the moment on the street who's looking for answers, right? Like in that very moment, you get pulled over and, oh boy, there's a cop behind me. I better get my lawyer on the phone right now. Or, the police officer walks up to you and says, sir, what are you doing here? And you automatically get defensive and think, all right, I better get my lawyer here right now.
Yeah, that doesn't work.
So when I say Crim Pro 101 for reals, I don't mean what you've heard or what you think or what you saw on TV or how you interpret, the Miranda rules. I mean, the way it really works, day to day, moment to moment, case to case, no matter what situation, right? It all starts with one thing. It starts with some event that results in the police being on scene. You could be at home, perhaps you're having a domestic dispute and your partner calls the police, or a neighbor overhears it and calls the police, or you could be driving your car and you could be pulled over, or you could just be walking down the street and an officer walks up and approaches you. Or you could be at an airport going to board a plane or coming back into the country or getting off a cruise ship.
You could be home role playing with your wife and the neighbor calls the cops and you got to sit there and explain to the cops why she was screaming, "No, burglar, please don't."
Right. Or in the spirit of Hanukkah, In the spirit of Hanukkah, when yours makes you confess to Nazi war atrocities.
Exactly. So, and then you're sitting there telling the officer, no, seriously, there's nothing going on.
So this is the start of the criminal process, right? Somehow, some way, the police get involved in what may or may not be a criminal situation. And it's their task in that moment to try and figure out the what and the why of it, and whether or not there's a crime, and if there is a crime, whether or not an arrest needs to be made. And so that's a calculus made by law officers in the moment that generally doesn't involve attorneys, unless, of course, an attorney happens to be the defendant.
Or again, to show you how complicated they are, if it's a special unit detective that has, like when I was in narcotics, they may call a state attorney, many times did, prior to making an arrest. But again, this just shows you the complexity, and we haven't even had anybody arrested yet.
Right, but that's a state attorney. That's a state attorney, not a private attorney.
Correct.
So, you know, I have had, and very recently, I got a call from somebody, from the wife of a client, who told me that the police had her husband in custody. She had been allowed to vacate the premises, but he was being detained, and she knew he was going to be arrested, and she wanted me to come to the scene. And, you know, I mean, I understand it. And of course, I had to explain it to her. But my arrival on the scene would not have helped her husband in the least. In fact, it might have hurt him, but it certainly wouldn't have helped him.
The only thing it could do is absolutely nothing or make it worse, but it never makes it better. Never.
So the cops are not going to generally, I mean, I guess anything is possible in any circumstance. And I'll tell you where I have had it happen, where the police will let somebody whom they are investigating in the moment actually call their lawyer with them there. And that's when they think they're going to get that individual to cooperate with them. So in a drug case, for example, if they're doing a grow house bust, or they're doing serving a warrant, search warrant, they may turn around and say to the guy, look, you know what? I know you want to cooperate. We want to make this easy on you. We don't want to arrest you. We want to help you. We're going to make all this go away. All we need you to do is cooperate. And they'll let you call your lawyer in the hopes that your attorney is going to be on board with them. Because, you know, it makes life easy for everyone, right? That's the police dream scenario.
I can't imagine I'm sure there exists, but I cannot imagine off the top of my head one time where I would suggest that my client speak to law enforcement. I can't.
Why?
Why? Is that what you said? Why?
Yeah,
exactly. Look at the smile on your face, because zero good comes of it.
I guess that's a really good pro tip that we can actually hit you up with right now, folks. Anything that you think that you can say to the police that will help you, your lawyer can say an awful lot better and 100% safer, because nothing that your attorney says, no matter how crazy, can ever be admitted in a trial against you.
Correct. But your comment is a confession. And so you'll understand the pro tip, cops are not talking to you because they're trying to be your buddy. If they're trying to get you to talk, the only goal is to get you to confess. Now, they're not stupid. They're not going to tell you, listen, I think you're a dirtbag and I don't like you and I think you did it. So do me a favor, confess so that I can make sure it's a rock solid case and I can prosecute you. Think about it. That's not what they're going to tell you. What they're going to tell you is what Michael just said. Oh, it's in your best interest. If you help us out, we'll help you out. You know, don't you want to get this off you? Don't you want to tell us your side of the story? These are the things they're going to tell you. They're not going to tell you the truth. You have to be very polite and just say no.
Well, and you know, I mean, it's good to be polite. You don't actually have to be polite, but you certainly increase your odds at a more pleasant experience, or at least a less uncomfortable experience.
Right, and it's not personal. It's not 90% of the time. It's not personal. The cops are just doing their job.
Well, even if it is, you know, I mean, at the end of the day, you know, we did a show on adages, right? And here's another one: 2 wrongs don't make a right. Even if the cop is off base, even if the cop is completely wrong, there's a time, a place, a venue, and a person to levy that challenge. And it's never you on the roadside or in the moment at your home or at the border or wherever. You know, I'll use this analogy a lot with clients. I liken the criminal justice system to a rip current. You know, everybody knows, or at least most people here in South Florida know what a rip current is. A rip current is a natural phenomenon that tends to suck you out into the ocean. It's close to shore, and if you get caught up in one, it takes you in the opposite direction, which is a very disconcerting feeling. If you've ever been caught in a rip current, you know,
Have
you have an initial.
Have you ever
I
been
have.
caught in one?
Yeah,
Scary.
and the initial instinct is always, holy shit, you know, you want to fight it, you want to panic. But if you understand the mechanics of the rip current, then you'll understand that what it does is it sucks you out, but it's a brief suck out. It lets you go, and then if you simply swim a few feet to one direction or the other, parallel to shore, you can get in safe because the rip current won't be there. But that's an awful lot to ask for anybody in that moment, in
Right.
that experience, while they are in it, to think rationally and calmly. So for us to be able to employ that same logic with the criminal justice system, that behooves every one of us. Just liken it to a rip current. If you fight it, if you challenge it, if you try and force your way through it, you're probably going to drown. But if you just chill and let it do what it's going to do, and then recognize that there's a proper, appropriate, and safe way to deal with it, in this case, we're talking about letting your lawyer handle it, you're going to probably be okay. Certainly better than you would be if you risked swimming against it, right?
Correct. And the best advice I think also we could add is if you are going to make a phone call on the side of the road, the person to call is whoever's going to get you a bondsman. That's the secret. Call somebody who's going to be able to figure out how to bond you out either with a cash bond or a premium bond with a bondsman. That's what you want to do, not us, because at that moment, there's not much we can do for you
Well,
other than
unless your lawyer is going to physically go post cash jail to get you out, your lawyer's not going to be able to bond you out of jail. A surety or a bondsman or a bondswoman, bondsperson has to get you out with posting bond, or you have to wait for the judge and then have an order of pretrial release. But again, having your lawyer on speed dial, not a bad idea, but Ed's 1,000% right. If I got arrested, the person I would be calling is my bondsman. If you don't have a bondsman on speed dial, then you have a family member or a trusted person, a close friend, somebody who you can count on that's going to answer the phone and then have the ability to make those calls. Because I'll tell you this, in a good percentage of cases, the police do not let you make a call. Period, frickin' paragraph. You are not entitled to that phone call until after you have been booked, which can be hours and hours after your initial encounter with the police. So if they let you make a call, you better make that call count, because they're not going to let you make 2, 3, 4, 5 calls until you get somebody on the phone or until you ultimately reach the right person. So if it's a wife or a brother or a parent or a cousin or a best friend or whatever, somebody who's got your six and is able to then either reach out to your bondsman or your lawyer, right? It's not a bad idea to have, if Ed got arrested, to have his wife call me, even though I'm the lawyer, because then I'm going to say to her, okay, don't worry, Mrs. Ed, I'll take care of this. Let me get a hold of the bondsman. I'll make a 3-way call. I'll patch you through. That's the way that works.
Although I'm not sure I would call my wife. She might let me sit in there for a couple of days just so she could have a little peace and quiet.
Well, like I said, it depends on who your go-to person is. So, whatever it is, that's really the focal point from the beginning is none of us want to have problems. And there are things that we can do to reasonably foresee and prevent some problems, but we can't prevent them all. For instance, I've been, as you know, I've been practicing law for over 30 years, and all I do is criminal defense, and I've handled well over 1,000 DUI cases. So one thing that I've learned over the years is I don't drink and drive, period. End of story. I don't play the I only had one drink with dinner game, because it doesn't matter. All that matters is what that crazy police officer on the side of the road has in his or her mind. First off, if they pull me over and they smell alcohol, and again, it could have just been the residue from one glass of wine or one beer that I had over the course of a 3-hour dinner. But if they smell it, I'm on defense. And now they're asking questions that I have to give answers to. Because if I don't answer their questions, guess where I'm going? Handcuffs real fast. If I do answer their questions, I'm still probably going, only this time I'm probably going with admissions, confessions, or statements against interest. Because when the prosecutor says, ladies and gentlemen, in argument where they're allowed to say it, ladies and gentlemen of the jury, What do you expect Haber to say? Yeah, he told him I only had one drink. He figured he could talk his way out of it. One drink over dinner, no big deal. But this officer knew better. This officer observed. This officer smelled. This officer saw. This officer. So they're gonna cram that statement down your throat, even though you think it's innocuous. Because what did you do? You admitted drinking, but maybe you didn't admit the actual amount of drinks you had, right?
Right, but
Maybe
at least
you lied.
But now you've given them evidence. The evidence is that there is alcohol in your system, and it's undeniable because you admitted it. So the amount of alcohol may still be debatable, but there's absolutely no denial that there was alcohol in your bloodstream because you admitted it simply by saying, I had one beer. And that's the problem. They now have evidence. And I'm going to say something else, Michael. I know you don't like chiming in on this, but I have several law enforcement friends, and I cannot divulge who they are from many different departments. If a cop tells you to get out of the car because he smells alcohol in your breath and he wants you to perform roadsides, there is a very, 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 very high likelihood that you are going to be arrested for a DUI. No matter what you say, no matter what you do, no matter how well you think you performed on those roadsides, because there is an unwritten policy that they are terrified of lawsuits. They're terrified. When an officer pulls you over, he calls in and he says, I'm doing a DUI examination now. That's a record. There's a record of that. So if I'm the officer and I pull over Michael Haber and I say, all right, I went from a traffic stop to a DUI, I'm doing a DUI investigation, because now they need to know that I'm off. I can't be going to a call. I can't do anything else because I'm in the middle of a DUI investigation. So I have to let them know that. And I give Michael roadsides and I say, you know what? Michael looks good to me. He wasn't. And Michael admitted he had a beer, but he looks good. And I let him go. And then 20 minutes, 10 minutes down the road, Michael gets into a car accident and he kills somebody. The person he killed, or even if he himself dies, the family is going to sue the police department and whatever, Dade County, Florida, city of Miami, they're going to sue. And that's what they don't want to have. So the minute an officer suspects you of being DUI, it's got to be 100% crystal clear, undoubtedly, that there was nothing wrong with you. You didn't have a drink. You didn't do any of that. So the minute you admit you had a beer, that ramps it up to, I can't let this guy go. Now, sometimes you do, but I'm telling you, they have been told, do not let them go if you even suspect that they're DUI. So you're not going to talk yourself out of this. Just stop trying. And I know you don't like to chime in on that, but
I don't know why you think I don't like to chime in on that. I'm okay with that. I mean, I think
there's no policy anywhere.
We're going to do a whole show just specifically dedicated to DUI. So I don't want to hammer too much on that particular subject. But listen, I happen to agree with you. When friends and family ask me, my standard advice is do nothing politely. No reason to be nasty about it, but refuse everything. No, sir, I'm not going to take your field sobriety test. No, sir, I'm not going to blow into your machine. I understand if you have to arrest me, you have to arrest me. We both got jobs to do. Your job is your job. My job is my job. I got to be a good citizen.
And here's what you guys need to know. Here's the pro tip. Don't panic because they have no evidence now. Now they have nothing. All the evidence they have is a driving pattern. That's it.
They still have they have their driving pattern and the other observations that they're always going to tack on because they're taught those observations in the DUI block at the police academy, and so it's almost always going to be odor of alcoholic beverage, bloodshot eyes, slurred speech, unsteady gait.
Right, but that's all they have.
Well, that's why a double refusal, as we call a refusal to do breath and field sobriety tests, is the best case scenario for the defense attorney. May not be the best case scenario for the client. And again, Ed, there are people out there who perform and pass roadside sobriety examinations. It happens. I'm just not going to be one of those people. I mean, I can't do them stone cold sober in the middle of the day in my own apartment, much less at 2:00 in the morning on the roadside with three squad cars and traffic driving by.
As a matter of fact, I'm going to out something else. They are taught. If you ever watch the DUI videos, you'll notice that the officers give you an example, but it's a very brief example. They are taught in their training not, especially if there's video, not to perform the roadside exercises. Because what if they make a mistake? What if they slip? What if they don't do it perfectly right? Now your defense attorney is going to show the jury, even the cop couldn't do it right. So notice on those DUI videos, he'll lift his leg for about 2 seconds and say, I'm going to tell you to do it, and do it like this, and then he put it down. And when you do your walk and turn, they take 2 or 3 steps and stop, and then tell you turn like this, and then take 2 or 3 steps and stop. They never do the 9 because they know if they actually do 18 steps, which is 9 up and 9 back, that there's a chance they might screw up. So they themselves know that even when you're sober, sometimes it's, and these are guys that are doing it on a regular basis. Keep in mind, they do these exercises on a regular basis, and even they know that they might screw up. So that's the reality of it.
Let's hop off DUI and get back on to the idea of the initial encounter with police, wherever it may be. Again, it doesn't have to be a traffic stop. They could show up in response to a call. They could be dispatched, or again, they could just happenstance walk upon you. So
anyway, you can get into an argument at a store with somebody and they ask you to leave and they call the cops. And for whatever reason, you feel like you don't have to leave because they have your product.
So any of these places. So let's go with Crim Pro 101 for reals. The first thing is that the police conduct this investigation, and at that point, you are detained. If there's a inability for you to freely walk away from whatever encounter it is, for Fourth Amendment purposes, you are being detained. And at that juncture, the officer has to have a reasonable constitutional basis, an articulable fact that they can point to, or probable cause, one of the two, in order to physically detain you. They can question you until they're blue in the face, and you're not obligated to offer any answers. But anything that you say can and will be used against you, which, again, here's another pro tip, Crim Pro 101, those words, anything that you say can and will be used against you, the words that were made famous by the case of Miranda versus Arizona, you don't get those words until they slap the cuffs on your ass and start to ask you questions. If they arrest you and don't ask you any questions, and I don't mean like, what's your name? I mean questions relative to the facts and circumstances of the case, what we would call an interrogation. If you are not in custody and being interrogated, you don't have to be read Miranda. You don't get those rights.
You'd be surprised how many young prosecutors and even some a little seasoned, certainly officers, don't understand it. And it's a very simple concept if you listen to the words. The officer only needs to read you your Miranda rights, which we all know. Anything you say can and be will used against you. You have the right to remain silent, all of that. If it's custodial interrogation, both have to be present. It's a very simple concept, but a lot of people don't realize custodial interrogation. So what does that mean? You have to be in custody, number one. So if you're not in custody, as Michael said, if you're free to leave, the officer can ask you anything he wants. He can ask you, did you do this? Did you commit the crime? What are you doing in this neighborhood? Why? You don't live here. As long as you're free to leave, but he's not going to tell you you're free to leave. He's just going to ask you questions. If you answer the questions, Michael and I later can't say that he violated your rights if you weren't in custody, right? But let's say you're in custody. He doesn't have to interrogate you, and anything you say can and will be used against you. So if you start blabbering and no question has been asked, it will be used against you, and he did not have to read you Miranda. So it's pretty complicated. I'm telling you, some lawyers even still don't get it. I think there are some judges in our building that don't get it. So I don't expect, and I'm not criticizing the judges, nor the lawyers, nor the officers who don't get it. My point is this. If we don't get it sometimes, certainly as a citizen, it's very difficult for you, especially like Michael said, when you're in the middle of that rip current and you're panicking, to be able to calmly think, am I in custody? Is he interrogating me? Am I entitled to my Miranda? Can I talk? Just be safe.
And there's even circumstances where it's opaque circumstances, a gray area, right? You get pulled over and the officer approaches you and the first words out of his mouth are, in fact, I think you mentioned this the other day on one of our previous shows. The officer says to you, do you know why I stopped you?
Hate that question. That question.
I remember
you I was doing 140 on the highway, but I don't know why you stopped me.
So, but whatever the reason, again, you have to understand when you answer that question, regardless of what your answer is. Your answer could be, no, I have no idea why you stopped me. Your answer could be, yeah, no, I took that stop sign. Whatever it is that you say, anything that you say, any statement that leaves your lips is admissible. It's coming in.
And they're going to write it down.
Well, and now with body, right? If they have body cam, it really is going to be your own words being used against you.
And back in the day, they would write it on the back of the citations. Everything on a traffic ticket, they would write it, or they would write it in the A form. You could have some fun if you'd like. You could have some fun. I mean, if you're in the mood and you really want to go to jail, you could say something like, "Well, I just came from your mother's house." I wouldn't suggest that, but it would be pretty funny when Michael and I see it on the body cam.
Well, when we do that DUI show, I'm going to read my A form that I've been carrying around in my briefcase for 25 years with the most incredible statement of facts that I have ever seen in my entire life. But we'll save that. We'll save that for another day. So again, let's just get back to this concept of Miranda and lawyers, because Miranda really involves two things, right? It involves advising you of the fact that anything you say is potential evidence, and also that you have the right to a lawyer. If you're placed under arrest, you have a right to an attorney. You have no right to counsel until you are placed under arrest. So let's go back to Crim Pro 101 for reals. There's 3 different stages of police-citizen encounters. The first is a consensual encounter. Officer Martinez walks up to Citizen Haber and says, "Hey, do you mind if I ask you a few questions?" If it's truly an encounter, Citizen Haber is free to say, "Matter of fact, I do mind," turn around and walk away with nothing else said, and Officer Martinez has to stop then and there. That is the definition of an encounter. It is a voluntary experience that either party is free to terminate at any point in time, including right at the beginning, before it even starts. The next level, they ratchet it up when Officer Martinez says, no, Haber, sorry, sir, you can't leave. I have to ask you some more questions, or I need some identification, or whatever it may be.
Let me give a brief example. So go with the first scenario. I come up and I say, "Mr. Haber, sir, can I speak to you for a few seconds?" And instead of saying, "No, I really don't, I got to go," Haber says to me, "Listen, if it's about that guy in the parking lot the other day, I don't know what, he was crazy." That now may have ratcheted up to me going to this point what Michael's going to say now. I don't know, didn't know anything. But somebody maybe made an anonymous tip about something that happened in the parking lot. And Michael says this to me. This now becomes, Michael, the next level up.
A detention.
Could be, right, because it could be reasonable suspicion.
So
I did get an anonymous tip about some guy getting punched in the face in the parking lot by a guy with a gray beard. I walk up to a guy with a gray beard, and the first words out of his mouth is, "If it's about the guy in the parking lot, I don't know anything about it." Now I got some.
Now you've just hide yourself. But let's go back to the one that I used, where the officer just walks up to you for no reason, and you say no, thank you, and you go to walk away. And if he lets you, it's an encounter. But let's say he doesn't, and he stops you, whether it's physically or by words, he detains you. Now you have a Fourth Amendment detention, and that's got to be justified. There has to be a legal basis for that officer to not allow you to proceed on your way. A good example is a traffic stop, right? It's a detention. Now, there may be something that occurs during the course of that traffic stop. For instance, he may smell alcohol. Let's say he just stopped me for speeding, but the minute he comes up to my window, my eyes are red, he smells alcohol, I'm slurring, I'm fumbling for my driver's license, I hand him a credit card, who knows? All these things happen. And when that occurs, now the officer has a basis to detain me and conduct a criminal investigation. But guess what? I'm still not entitled to a lawyer, and I'm still not entitled to a Miranda warning. Why? I'm not under arrest. I'm merely being detained. If it ratchets up to the next level, which is an arrest, where there's got to be full-blown probable cause to believe that I committed a crime in the jurisdiction, or that there's a warrant, or there's some other reason for that officer to slap the cuffs on me and book me into a jail, or PTA me if he chooses, promise to appear, he'd give you a written notice, what we call a paper arrest. But either way, once that arrest occurs, that's when my constitutional rights kick in, formally, whether I'm read Miranda or not, because he doesn't have to read me Miranda if he's not going to ask me questions. But pro tip, if you're a citizen and you're in this boat, you need to know going into it, shut up, because if you speak, whatever you say can and will be used against you.
Correct. And again, let me just not complicate it too much, but I want you guys to understand just how complicated it is. There is no.
Just look at the flow chart.
Yeah, really. There is no bright line rule on when you are in custody. The only thing the courts have determined that there's no doubt you're in custody is when you're cuffed. But the mere fact that I tell you, Michael Haber, have a seat over here on the sidewalk, you're not going anywhere, that could be custody. It may not be, but it could be. So it becomes so complicated. And that's why lawyers get paid the big bucks, is to sit there and explain, hopefully the right way, to the judge what is our argument and that we're right, that you were in custody, even though you weren't necessarily cuffed. But I can tell you for a fact, the case law is crystal clear. If you're cuffed, you're in custody.
So dovetailing on what Ed just said, there are things that are Crim Pro that you wouldn't know are Crim Pro. And one of those things is what your lawyer has to do. How is it that we come to this conclusion to make this argument? I mean, Ed doesn't just wake up in the morning and decide going to court and argue X. He's got to go through case law and read cases and look at fact patterns to find a scenario that's so remarkably and strikingly similar to yours that has already been viewed by another court and ruled upon. And that way we can use the law, the case law, to argue the point. Because I think we talked a little bit last week about statutes, right? Anybody can read a statute. It's just like reading a book or a cartoon or anything else. It's only words. But the statute itself is a mere guideline. It's the interpretation of the statute that matters. For example, let me give you a great example, folks. There is a statute that says if you're driving a vehicle in the state of Florida and you want to make a right-hand turn or a left-hand turn, you have to use your blinker. Why does that statute exist? The statute exists because it's a safety measure for other vehicles on the road to be able to know what the intent of other vehicles are so that they don't have accidents. It's designed to reduce accidents. So memo specifically to 305 drivers, you have turn signals, frickin' use them, okay?
And a cop can use that as a reason to stop you.
So anyhow, there's a statute. The statute doesn't explain the why of it. It doesn't get into the basis for it. All it says is if you're turning right, you got to use your right-hand blinker. If you're turning left, you got to use your left-hand blinker. Now, case law that has interpreted that, because people have gotten cited for that, and obviously things steam pile, right? So some poor son of a bitch is riding his motorcycle and he whips that right-hand turn. It's a rolling stop. He doesn't use his blinker, whatever the case. And the officer pulls him over. And when they pull him over, one thing leads to another. And ultimately, they wind up arresting him for possession of cocaine. He picks up a felony from what would have been a traffic stop. His argument in getting that cocaine suppressed and getting the case thrown out was a novel argument. And it was exactly this. It was, yes, he did not use his blinker or his turn signal. But the reason that the statute was passed was to protect other drivers. And at that moment, there was no other traffic. The defense attorney was smart enough to have deposed the police officer before the motion was filed. And he locked the police officer into sworn testimony that said there was no other traffic on the road. There was nobody traveling in any other direction that was visible to the officer except for the officer himself. The officer was several car lengths behind the defendant. The defendant's failure to use a blinker didn't in no way affect the officer's ability to operate his vehicle or presented any safety violation. It was strictly a technical stop. And the fruits of that technical stop ultimately turned into a felony, which the officer had absolutely no clue was going to happen when he made the stop. The intention of the stop was to cite the guy for failure to use a blinker or for the rolling turn, whichever it was. Well, ultimately, the court came back and said, you know what? No harm, no foul here. The guy's behavior, even though he didn't follow the language in the statute, didn't affect anyone else, and therefore we're going to find this to be an unlawful traffic stop. And they threw out the cocaine, and the case wound up getting done.
Right. And the cocaine gets thrown out for what every criminal lawyer that has done this for one day knows. It's called the fruit of the poisonous tree, meaning if it wasn't for the stop, which was illegal, you never would have gotten to the cocaine. And that's a pretty basic standard. Again, in Crim Pro 101, we all understand the fruits of the poisonous tree argument, whereas if we could get the stops thrown out, then everything that came after is just a poisonous tree and it shouldn't be allowed in.
So
and
here's another
law. Again, and that's case law.
Here's another good example of that. We've talked before on previous shows about the concept of stop and frisk or Terry stops. So a police officer observes you in some kind of suspicious manner that suggests to him that you either are committing, have committed, or about to commit a crime, and he detains you, and he's entitled to conduct a limited pat-down of your outer garments, not a full-blown search of your person, but a limited pat-down of your outer garments in order to make sure that you don't have a weapon. Perfectly sensible, proactive measure to protect everybody. So he pats you down and he finds a pack of cigarettes in your pocket. He pulls out the pack of cigarettes. Obviously, it's a pack of cigarettes. Now, he could take that pack of cigarettes and set them on the ground, set them on the floor, keep them in his own custody. He could give them back to you. But probably not give them back to you, because what if there's a razor blade secreted inside of them? But once he's got that pack of cigarettes out of your hand, there's no way that you have a weapon. And if he then opens that pack of cigarettes and finds your little baggie of cocaine in there or your pre-rolled joints in there, guess what? That's probably going to be the fruits of the poisonous tree, because that's an unlawful search and seizure. By Terry or Florida stop and frisk law, he was limited to patting you down for weapons, not searching containers on your person for controlled substances, which couldn't realistically contain a weapon that presents a danger, right?
Not even. There's a famous case that I read about a can of altoids, and the officer felt he said something hard. But again, the court came back and said, yeah, but just because it's a hard container doesn't mean it was a weapon. You have to feel a weapon. And you can't even make the argument that, well, what if a weapon was in the container?
Well, right, but he could remove the altoids from your pocket. Yeah. He could hold that in his hand. And the question is, can he flip open those altoids? And the answer to that question is, not without a warrant, he can't.
Correct.
I mean, I guess arguably, if they arrest you, and they're going to take you into, physically book you, arguably at that point they might be able to open them for inventory purposes.
Correct.
But for stop and frisk purposes, that exceeds the mandate. So Crim Pro 101, how far can the cops go? They can go far enough to confirm or dispel their suspicion, which is very similar, again, going back to DUI. He pulls me over for speeding. He smells alcohol. He sees the telltale signs. He's now got a reasonable and articulable suspicion to conduct an investigation. What is the purpose of that investigation? It's very simple. It's either to confirm or to dispel his suspicion, right? So, go ahead.
I'll give a war story that's not related to traffic stops.
Good.
But it was pretty fun. And Nick was it Nick? No, it was Tommy. It was another officer, City Miami officer, when I was in the narcotics unit, calls me. He went into a drug hole, and there was a floor safe, like not a little safe. It was probably about 100 pounds, but it's one of those little safes that you could probably pick up and carry, but it's heavy. And he had everybody in there, and of course, he wanted them to let him open the safe. And these jamokes, thinking they were smart, all said that it wasn't their safe, so they weren't going to give him permission because they don't know. It's not their safe. So he calls me up, and I said, get everybody in the room. There were about 8 guys. I said, get everybody in the room. I said, ask every single one of them if they live in the house and who does. About 4 guys said they live there. And I said, ask them if anybody else lives there. And they all said, no, nobody but us 4 live here. The rest are visitors. And then I said, okay, ask, is that anybody safe? And they all said no. I said, okay, take it. And he goes, are you sure? I said, absolutely. It's abandoned property. It's their house. Nobody owns the safe. Well, I guess it's abandoned property. So that's how we got around the warrant. But again,
it's a good haul if the cops find a nice chunk of cash in there.
They did. They found coke. They found marijuana. They found guns. They found a ledger. They found fingerprints on the ledger. It's a pretty good haul. But what's the lesson for people now? Obviously, I'm not condoning criminal activity. But what I'm saying is these guys thought they were so smart that they opened their mouth. And they opened their mouth too far. And the law allowed us to do something because it was abandoned property. You got to be careful. If there's nothing else you're going to learn from this show, is keep your mouth shut. What is it? What you're saying, Mike, that I think you should trademark?
Up X2. Hashtag Up X2. Shut up and lawyer up.
You should trademark that. Copyright it.
I had to talk to Mark Stein about that.
Every time somebody said up X2, they got to pay you royalties.
Yeah, that'd be nice, wouldn't it?
It would.
So Pro 101, these are the tiers, right? You've got an encounter, you've got a detention, and then it ratchets up to an arrest. So what happens when you get arrested? One of 2 things. Either you get paper arrested, which means they give you a piece of paper, a notice to appear, This happens in a lot of misdemeanor cases that don't involve domestic violence or DUI. So like shoplifting cases or trespassing cases or, things along those lines where there's cops don't even want to go. It's more of a hassle for them to transport you to the jail and do the paperwork to book you in, as opposed to just giving you a piece of paper and telling you you're going to get a court notice in the mail. The alternative is they arrest you. Now, here's another pro tip for you. On any case where you could get a paper arrest, the officer has the discretion, and it is unbridled 100% to that officer in that moment in time, whether they give you that paper arrest or they take you down. The difference maker is almost always going to be your attitude. Not so much how you view your attitude, but how the officer views your attitude. You may think that you're doing everything perfectly fine and 100% well within your rights and blah, blah, blah. But if the cop thinks that you're being a jerk, well, we bump into that old police aphorism, you might beat the rap, but you ain't beating the ride, and they will make it miserable for you. So if your attitude is viewed as neutral or positive, the odds are, if the officer can give you a break and PTA you or NTA you or paper arrest you, they're going to, because it's a lot easier for them. And I got to think in most situations like that, simple possession of marijuana. Let's say you've got, less than 20 grams misdemeanor amount on you. The cops don't want to roll you in for that. In fact, many jurisdictions here in Florida now have official ordinances. It's not a state law, but we have local ordinances on a municipal and county level throughout the state. And they allow additional officer discretion to give you a civil infraction, which is like a ticket that carries no points and does not ever get entered into a criminal database. Well,
Right.
Why would a cop do that as opposed to giving you the misdemeanor PTA or physically booking you? The overwhelming odds, look in the mirror, okay? The
Absolutely.
overwhelming odds are how the cop perceives you as having treated her or him. If they think you're a jerk, they're going to make your life miserable more times than not.
I was talking to a homicide detective friend of mine. I've known this guy probably 15 years. He's now a homicide detective. And we bumped into each other in the hallway. I forget how the topic came around. And I asked him to whether he agreed with my assessment. And he said he did. And this was my assessment. I say there's 10 of generally speaking, in my experience, you take all law enforcement officers from every department, everybody, every law enforcement officer, especially here, the ones I've encountered here in South Florida. 10% of them are just dirtbag pieces of crap that probably need to be indicted themselves and be arrested. Those are the guys that would plant the evidence. Those are the guys you see on TV doing stuff that you're like, oh my God, like, remember that guy in the park that shot some guy running away in the back and then planted a gun on the guy? Those are maybe about 5 to 10%. They exist. Then there's the other 10%, which are the Joe Cop, Joe Friday, never do anything unethical, would never dream of doing anything unethical. These guys are like, a poster child for what you would want as a law enforcement officer. But the other 80%, you're telling me the numbers lower. Again, but here's my point. Let me get to my point. The other 80%, which is the important part of this story, are human. They're human. They don't mean to do things intentionally. They have bad days. They have good days. They make mistakes. They arrest people when they probably shouldn't have, but they really thought they should have. They have bad days at home when they're in a bad mood and they're pissed off, and then you come along and you just gave them a reason to be an asshole. So 80% of the cops out there really are going to react to you. That's the lesson here. They're going to react to your behavior. So even when they're having a bad day, you try to be the best in your best behavior, and you have a good day, and you'd be surprised. A lot of times it turns out in your favor.
So if you're not a complete, let's go back to regular traffic tickets, okay? Not DUIs, but just basic traffic tickets. I don't do them. I haven't done them in years, but obviously I've done thousands of traffic tickets over the course of my career. And if you have a legal defense, like we were talking about for the guy who was stopped on the motorcycle without using the blinker, if you have a legal defense, that's one thing. Like for instance, a very common error that police officers, at least rookie police officers, make here in Florida is they give tickets for careless driving or reckless driving, which is a criminal act. But let's go with the misdemeanor, with the infraction, careless. And on the ticket, they just check the box that says careless driving. That's not good enough. On its face, the ticket gets thrown out because the case law, again, the court interpretation of the careless driving statute requires the officer to write on the citation those facts and circumstances that constituted careless driving. In other words, you can't just say careless. You have to say what it was that was careless. Like, for example, driving aggressively and not using a turn signal. Whatever it may be, there's got to be some indicia of something that is not its own independent infraction that designates why it is careless driving. And if that's not there, the ticket gets thrown out. Right. So apropos of that, absent a defense, so let's say it's just a basic speeding ticket. I got to say probably 98 out of 100 times, I would go to traffic court, I'd show up early, I'd find the officer, I'd introduce myself, and I'd talk to him, and I'd show him the ticket. I'd say, listen, I hope that this person didn't give you a hard time. It's my cousin or a good friend or this or that. I would never call him a client. I'd always personalize him. And I would say, I have to do this as a favor. I don't, I'm hoping that there's some way that we can work this out. Maybe you see fit to give him some slack. I know you had to give him a ticket in a moment, but maybe, and it's just being nice. It's what I'm telling you to do on the roadside, okay? Here I am doing it in the courtroom. There's no legal brilliance here. There's no legal research. There's no brilliant cross-examination. It's simply an appeal by one human being to another human being to do a courtesy. And you know what? 98 out of 100 times, they throw in the towel and they're happy to do it. Why? Because it doesn't matter to them. And I will tell you that absent, as Ed said, that 10% that really are Johnny, officer. So there are times where you get a ticket from a cop who would write his own mother, okay? It don't matter. They have zero tolerance. And there are some like that. And the truth is, their colleagues don't even like them because
Correct.
They're sticklers. No. And so what happens is, an officer has a family member that gets cited by him, right? Of course, a family member comes home, gives him the ticket, says, listen, I didn't say anything. I didn't do anything. I kept my mouth shut. You always told me to do that. I did it by the book. You'd be so proud of me. And then the cop family member who gets the ticket looks at it and says, I am proud of you, but guess what? There's nothing I can do about this.
You're
you better call and hire Martinez because this guy is going to go after you like you're Hitler. So, you do have that brand, but overall, the same rule applies to us. Now, there are times, again, Crim Pro 101, right? We may be in a motion to suppress. We may be in a motion to dismiss. We may be in a stand your ground motion. We may be in a trial. We may be in a deposition. We are in some adversary proceeding where we are questioning that officer, and our client's liberty is what's at stake. And under those circumstances, we're going to do our job. But still, how we do our job is very important. So if we go in there on the attack and treat them like subhuman animals, we can expect to reap the consequence of that, as opposed to doing the same thing in a respectful, professional, ethical manner where we accomplish the same objective on our client's behalf. We just do it with a little bit of sugar instead of a lot of spice. Of course, there are exceptions. Sometimes you got to be the bad guy.
But here's the thing. Happen. There's always time to turn into the bad guy. Always. There's always time.
Another little tactic, another Crim Pro 101. It's not really a Crim Pro, but it is a pro tip. If I have a case where I'm getting nowhere, all right, I've got problems, and I know that it's there's just nothing I can do to get done what needs to be done. I can't accomplish it. I might bring in Martinez. I might have my client authorize me to bring in another lawyer so that I can specifically either go bad cop myself, knowing that Martinez is going to come in and be the good cop and clean it up, or I remain good cop and I bring Martinez in to be the bad cop and try and steer them towards me. So it's kind of a little psychological ploy, but these are tactics that we sometimes have to engage in because, look, nice or not, a trial is a war, okay? There is a clear winner and there is a clear loser at the end of the battle, all right? Somebody's walking out happy, somebody's not. So, and in some
You
ways,
know,
everybody.
I'll give you an example. You can look back years ago. I don't know if you ever remember Larry Holmes when he fought Muhammad Ali. Did you ever see that fight? Larry Holmes, trained with Muhammad Ali. He was his sparring partner for many years. He idolized Muhammad Ali. He saw Muhammad Ali as like his hero. It was his mentor and his hero. But by the time Larry Holmes came around to fight, Muhammad Ali thought he was still young enough. I think he came out of retirement to take it. And if you look at the fight, Holmes is pummeling him. At one point, Ali can't even defend himself, and Holmes is looking at the referee like, "Are you going to stop this?" And the referee doesn't stop it, so he keeps hitting him. It wasn't personal. It's not personal when we go to trial. Sometimes we got to pummel the opponent,
but sometimes
you don't want to.
But sometimes it is personal because sometimes it's made personal.
Yes,
and it's a shame. We've talked about this many times. The skill and experience level of prosecutors varies. It runs the gamut, just as it does with defense attorneys. But when you get to be our skill level and our age and our experience, you and I, and we go up against prosecutors who are right out of law school, and they want to school us on procedures and law, it's insulting. And so you try and talk to them, you try and ration with them and be rational and get them to see things, as they are, but they're so lockstep regimented in their ways, and they don't know any better, and they're not willing to take the next step and learn. I have many former prosecutor friends and current prosecutor friends, but one thing that they all have in common, and I know you will agree with this, as young prosecutors, the best lawyers that I know who were young prosecutors took beatings and got lessons from great defense attorneys. So when you were in your first year of prosecuting and you went up against a guy with 25 years of criminal defense experience, you might have gotten a beating, but you know what else you got? An education. And if you were smart enough to look at it that way, instead of getting a chip on your shoulder and being pissed off at that guy for the next 20 years, instead send him a Christmas card or a Hanukkah card and say, thank you, because you made me a better lawyer, right? That's a way that we can all kind of kumbaya moment work together a little bit. And unfortunately, we find more of the other side, more of these young, I don't want to say dumb because they're not dumb, but they're just not
naive, inexperienced. They're not dumb.
They're not looking at the big picture. So, it's not always about this particular case. I mean, it's always about that client and that case, but there's more to it, right? You and I know, and we have seen lawyers that have overstepped the ethical line on a given case, and it's cost them for the rest of their careers. In fact, sometimes it costs them their careers. You can't do that. You have to maintain your integrity no matter what. You have to maintain your ethics no matter what. You cannot compromise those things.
And that's what we have to do as defense lawyers too. That's why we do it the way, you and I do it that way. We do it because we have to maintain our integrity. We have to maintain our ethics. And so no matter what the young look, I'll be honest with you, you're a better man than I am. That's why I don't like doing misdemeanors, because most of the misdemeanors are always with the young prosecutors. And it's like finding a needle in a haystack to find one that has self-awareness. And I got to tell you honestly, Michael, myself included, I was not as bad as some, but I look back on my career when I was a very young prosecutor in misdemeanor land, and some of the things that I said and did that I was like, I wish I'd had the experience to know enough that I was doing something.
But that's the learning curve. That's the learning curve. So how do we translate that into a pro tip, for the folks? Look, don't micromanage your lawyer. All right. If you hire an attorney, here's your pro tip. Hire the lawyer that gives you a warm, fuzzy feeling. Like you went out on a first date with somebody and you came home and said, God, I cannot wait to see her or him or they or whatever again. Right? If you have that feeling about your lawyer, trust your lawyer. Let your lawyer do their job. Don't micromanage them. You could certainly, and you should, want to know what's going on. Your lawyer, actually, If you have a lawyer like Ed or I, you're going to know what's going on one way or another because you're going to get periodic updates from us in email because we're smart enough to document our files and keep records of the fact that we communicate with you and we keep you informed of the status of your case. That's one of the big ticket items that lawyers get disciplined for. So we're very attuned to doing that. If we get an email from the prosecutor with discovery or if we file something, you get a copy of it at the same time. We make sure you have it in your file. Remember, Mr. DeVlaming was telling us last week, whether even if the prosecutor says to you, yeah, you know what, I'm going to offer your client 87 years of hard labor, you know, and your client has already told you I'm not taking a day in prison, you still have to convey the offer. It's still got to be communicated. So pro tip, hire the lawyer that gives you that warm, fuzzy feeling and then trust in the warm, fuzzy feeling. Let your lawyer do the job.
And here's one thing that I've said this many times on other episodes. If you've heard it and you took it to heart, I apologize that you're hearing it again, but I don't know who's listening. The lawyer that you see on TV most of the time, the one that comes in like a hurricane and is yelling and screaming at everybody, and pardon my French, is whipping it out in front of everybody and yelling at the judge, that is the absolute worst lawyer you could have in any given situation. Here's an example I like to give. Remember the movie Jack Reacher?
Sure. The first one or the second one?
The first one. Remember when he gets in the bar?
The one where he says, you asked for it? Just remember you asked for this?
Those four guys. Did he want to fight? He didn't want to fight. He was trying to end this without a fight. Now, he knew he could kick all their asses. He knew he could win the fight against all five of them. But what did he try to do? He tried to end it peacefully and calmly. When they didn't want to end it peacefully and calmly, he took care of business. That's the kind of lawyer you want. You want a lawyer that even if the prosecutor wants to fight, will try and help him understand that we don't need to fight.
So,
but then if he does, all hell's going to break loose and your lawyer can fight.
The last stand your ground hearing that we did that you were sitting in the courtroom and watching is a prime example of that.
He made me a part of it.
He
made me a part of it.
I had you in there on purpose. You were my puppet. You were my tool.
Well,
and you worked. You remember that we had the witness from the witness stand started barking at the judge about, why is that guy in the audience looking at me? Who's that guy in the audience?
Why
is he smiling at me?
And I didn't say a word, but I kept thinking, because you're going down in flames, you lying bastard.
So the point that I bring that up for is to dovetail on what you just said, which is there's an example of, I went to the prosecutor and I said, look, I understand that you got this case thrown on your lap, but you don't know all the facts. You only know the facts that the victim sold to the officers who made the arrest. You don't know the whole story. Let me give you the whole story, and I think you'll understand. And the prosecutor said, I don't care. So we drafted a motion. We prepared our exhibits. We filed everything and put it in the form of a stand your ground motion, and the prosecutor still said, I don't care. Then we went in front of the court, and we put on a prima facie case. We put on our client. He testified. The judge said, yep, let's go forward. Prosecutor, call your witness. They put this guy on the stand, and he completely flubbed the case. And the prosecutor kept going. He didn't stop. He put on over an hour of direct examination that was so, at the end of even before the end of the direct, during the direct, the prosecutor should have null-prossed the entire case just based upon the insane things that his witness had said on the witness stand under oath. But then after 2 hours or 2.5 hours of cross-examination and back on to redirect, the prosecutor had to be called sidebar by the judge to say, are you serious right now? You really want to keep going with this thing? Until the prosecutor finally got the point, because it was the judge telling him, you know, you've got some serious problems here. You have opened up Pandora's box, and I don't think you want this thing to stay open. You got to shit can it now.
And you're a better man than I am, because I think personally, honestly, Michael, I think it was borderline unethical. Certainly something that he should be spoken to and reprimanded for. I don't think maybe the Florida bar should get involved, but I think that my former office, if Kathy were to find out about this, or his deputy chief, that they should just call him into his office and say, look, this is not how the reputation we want this office to have. So
for me, listen, I leave it to the judge to handle that. I'm not snitching out prosecutors.
No, neither do I.
I mean, if it were something personal to me, right, I might, but even then I probably wouldn't. I'd hire somebody. I'd call you and say, Martinez, handle this. but I just wouldn't do it. I think when judges, my guess is the judge took that prosecutor into chambers and gave him an education and made this a learning experience. And if not, if the judge was really offended and thought that this crossed an ethical threshold or what have you, then the judge would make that call herself.
Yeah, and I don't think this kid, just so we're clear, I don't think he crossed an ethical threshold. I think he came close to it because of his zealousness. I don't think he did it on purpose. That's what I'm saying. I wouldn't report him to Florida bar, but I think, and I wouldn't report it to anybody, but I hope that the judge said something to him, or maybe whoever he called, he had to call a supervisor to get permission, will call him into the office and say, listen, I understand you were zealous, but you're here to do justice. You're not here to win at all costs.
Well, the good news in that case, justice was done. My client was acquitted. He walked out of the courtroom a very happy guy.
He should.
And with that, at 3:02, let me conclude episode number 23 of At Your Service with Haber and Martinez by saying I hope you guys learned a little something about the real workings of Crim Pro for reals, and that you have a little bit more of an understanding, especially when it comes to Miranda and statements and when you're entitled to counsel and when your lawyer can actually start to become effective.
And at all times, they should do your catchphrase. At all times, always remember.
Hashtag UpX2. Shut up and lawyer up.
Shut up, and lawyer up.
Thank you all for watching. Thank you, Ed, for joining me.
Thank you, brother.
Wish everyone a good work week and happy start of the holiday season. And we'll see you all next Monday on episode 24 of At Your Service.
Bye, everybody.
Take care.